10:05, and I would like to go ahead and get started with our next session, Hot Topics, Impacts of Current Cases on Retirement. And I will tell you, this is definitely an ever-evolving topic right now. And with that, we have Scott Wagner, who is one of the partners at Moores, Manning & Martin, one of our premier sponsors that we're happy to have. And even more, Mr. Wagner is one of our board members, and we love having him. And if anybody is interested in getting more involved with Espen, we would like to encourage you to do so. But with that, Mr. Wagner focuses practice on counseling clients on matters relating to design, drafting, and administration of defined benefits and defined contributions, tax qualified and non-qualified retirement plans. So basically, he helps make sure your retirement plans are above bar, would be the best way to say that. And I am honored to introduce Scott. This is definitely a Scott-filled day, so great, Scott was the way I was going to do it, but decided it was a little too cheesy. But Scott, thank you for your time today. And with that, I'm going to turn this over to you.
That sounds great. Thank you. I'm going to try to share my screen here. Let's do that. Can you all see my screen? Michelle, are you seeing the presentation?
We have your presentation pulled up and it looks great.
Perfect, thanks. Well, thanks for having me today. This is kind of one of those grab bag topics of hot topics related to employee benefit plans. We should call it pandemic edition because a lot of the topics that we're going to talk about today are sort of the hot issues and questions we are answering from our clients every day. And you know, at the backdrop for all this is how administration and compliance challenges crop up with the current pandemic situation, either because employees are working remotely or on furlough, or perhaps there have been company-wide changes and potential layoffs. So we're going to go through a couple of the kind of key questions we're getting and advising clients on every day. And then I'm also going to turn to some recent litigation to talk about some things you should be thinking about from a committee perspective. If there are any questions throughout, feel free to ask questions. I plan to reserve a little bit of time at the end for questions if there are any, or we can talk about anything you guys have in your mind. So today I wanted to talk about furloughs and layoffs and how that impacts your benefit plans. I wanted to talk about partial plan terminations, some of the cost-saving measures that we're seeing companies employ right now to shore up cash, either reducing employer contributions and some of the landmines that come with that. Some of the remote witnessing of plan election changes that recently happened and some of the administrative challenges that we're seeing with remote witnessing. And with that, I wanted to talk briefly about electronic disclosures, which you all may have had a briefing on already, but just to mention here as well, some of the administrative challenges that come up with working remotely and how to take advantage of certain new electronic disclosure rules to help. And then sort of finish off with a reminder about fiduciary best practices and some of the recent litigation trends. So furloughs and layoffs. So, you know, at the start of the pandemic, a lot of the work that we did was helping clients determine whether they needed to lay off or furlough certain of their employees. Many of our clients have brought employees back. We still have clients who have not brought their employees back from furlough, and they are on either an indefinite furlough or potentially are moving into a layoff status. And so, you know, while this issue was particularly important in March and April, it's becoming more important now as companies are determining, you know, are we going to pull back from furlough or are we going to move to a more permanent layoff status for now? And so to start, you know, what's the difference, right? So when I talk about furlough, I'm really meaning an unpaid company leave of absence, but the employee is still actually employed by the company. So they're not being paid, they're not on FMLA leave or any other type of health-related leave or CARES Act leave. They are on an unpaid leave of absence from the company versus the layoff where there's a permanent termination of employment. Of course, furloughs can start to look like layoffs when the furlough goes on indefinitely, right? So you get 4 or 5 months in, and you have to ask the question, is this person really still actively at work? Is this person still an active employee of the company? And that raises a couple of health and welfare plan issues. So most health and welfare plans will have an active at work exception in the eligibility rules, which will say that you're no longer eligible for coverage once you're no longer actively at work. And that actively at work standard will not usually be defined by plan document. It'll just be a generally understood term based on company practices and sort of the expectation of the carrier if you're a fully insured plan, or the expectation of stop loss if you're a self-funded plan. Most companies can get exceptions to the active at work requirements. So if you have employees that are on furlough and you have a question of whether these employees are still actively at work, and generally in my mind, that question should start kicking in around 60 days. So 60 days of unpaid leave of absence, is this person really still actively at work? And if you have people who are expected to be on furlough for 30 days, 45, 60 days or more, I would have a conversation with your carrier if you're a fully insured plan, or your stop loss if you're a self-insured plan, to get an exception or to define an understanding of what actively at work means with respect to your health plan with regard to those specific employees. Some stop loss carriers are saying, okay, sure, we'll do 120 days and then come back and talk to us. Well, that was in April and May, and a lot of our clients who still have employees on furlough are now having to go back to the table and say, hey, we still have people on furlough. And in my experience, it's been fine to get additional exceptions to that. I think a lot of carriers and stop loss are interested in working with clients to make exceptions given the current pandemic situation, but they're closely monitoring it. And what I always caution clients on is you don't want to be in a situation where you're disputing a claim with a carrier or stop loss because you didn't call them and get the actual exception. So it's an easy thing to do. And to check in on and say, hey, we still have people on furlough, or maybe you're putting people on furlough for the first time and saying, hey, this group we're putting on furlough, this is what we want to do. This is expected. We expect it to be 90 days, 120 days, and then we'll check in just to get that coverage so that later there's not a challenge. If you guys have ever been through a claim dispute with a stop loss carrier, it's not always the easiest fight to win, right? Because they want to deny the claim because they say someone is not eligible for a benefit under the plan. This is an easy one for a stop loss carrier to flag and say, hey, that person hasn't been working for 4 months. Like, they're not actively at work under the terms of the plan, and you didn't get an exception. So it's an easy one to fix if you get the exception up front. And even if you got that exception, check in with them, because it's about that time when everyone said, okay, we'll agree to talk again in 100 or 180 days. We're at around that point now. Retirement plan issues that arise, I guess the main question is this actual separation of employment? Do you get a distribution right? So like with a furlough, where there's not an actual separation of employment, you technically would not have a distribution from the retirement plan, versus an actual layoff. When you have a separation from employment, you're going to have an actual separation. And a lot of it is based on the intent, right? So what is the intent of the parties at the time that the event occurs? Is this intended to be a permanent separation, or is this intended to just be an unpaid leave of absence? So I know a lot of administrators are grappling with, is this a furlough? Do they get a distribution right? Or do we have to wait and see if it actually becomes a permanent separation? Plan loans. So recent regulation extended the period of time in which participants could pay loans if those provisions are incorporated. And for furlough, it certainly helps, right? So people who are on furlough not being paid, that those plan loan extensions, the companies who have taken advantage of it, have allowed their employees to suspend payments. Now, the general rule still applies to plan loans, right? So if you miss a plan loan payment, then you have a cure period. It's generally, you'd have to check the plan document, but the maximum is, the end of the second quarter following the quarter in which the missed payment occurs. So you could, have a situation where your employees are missing loan payments, and even if you didn't take advantage of the extended repayment options under the CARES Act, you could still have your employees come current on those plan loans during the cure period. Of course, if there's been an actual separation, then you would treat that loan as you would treat any other loan that's outstanding on the day that a participant separates. With this also comes break in service and crediting issues. So, again, are you having people who have actually had a break in service and walking through the break in service rules under your plan, depending on whether it's a furlough or a layoff? With employer and employee changes, we always want to think about partial plan terminations. So a partial plan termination occurs where it's based on the facts and circumstances, but if a partial plan termination occurs, then all participants who have had a severance of employment during the applicable period must be vested. So if you have people who are separating from the company and it reaches the level, and I'll talk about this, what the level is, but if it reaches the level of partial plan termination, then everyone who separated during the plan year would need to be vested in their accounts. The IRS treats that as essentially a plan termination, and as a result, participant accounts must be vested to the extent funded. So the IRS applies a 20% rebuttable presumption here. If there's been more than 20% of turnover within the company during the year, then there is a rebuttable presumption that there's been a partial plan termination. And most companies would say, we're not going to rebut the presumption by using facts and circumstances because the IRS could disagree with us. So if it's more than 20%, we're going to go ahead and invest those accounts. To determine that, you only look to company-initiated separations. You do not have to count voluntary terminations, right? And this is important and helpful here because you could have situations where, a lot of your turnover was voluntary throughout the year. And so if you're only looking at employer-initiated terminations, then a lot of times when companies just run the numbers of how many people, how much turnover have we had, they'll say, oh, well, just based on the pure number of separations we've had, we meet the 20% presumption. But you can remove from that formula any voluntary separations. What you got to be careful here of is constructive discharge. So if you have a situation where maybe an employee just sees the writing on the wall, right, that they're going to be terminated, they're not formally terminated by the company, but the company kind of gives them the indication that, hey, this is coming, find something else. And so you do typically want to count those as company-initiated separations to be safe, because constructive discharge does count as an employer-initiated separation. A recent example, I was working with a company and they had an acquisition during the year. And as part of the acquisition, they had some redundant positions. And so they eliminated certain positions. Now, some of the employees were informed that their position was potentially going to be eliminated. And so a lot of those employees resigned. And so the question was, do we count those as resignations or do we count those as employer-initiated separations? And conservatively, we counted them as employer-initiated separations to be safe, right? Because, if the position would otherwise have been eliminated had the employee stayed, the IRS could say, hey, that's actually a company-initiated separation, should be counted toward your 20% presumption. While this is important to keep on your radar, most companies will want to wait until the end of the year to make this determination. The denominator of determining how many employees you have for the plan year is determined by any new hires, right? So as companies are ramping back operations, people are going back to work, you might be rehiring some of the employees that you let go, or just filling other positions. And so you generally would wait to the end of the year to be able to count those new employees as part of your analysis to see whether you've had that 20% turnover. One other thing just to mention, it's often overlooked. Even if you're below 20%, it's still based on the facts and circumstances. So you'd still undergo an analysis, even if you're below 20%, to say, hey, do we have a partial plan termination here? Another thing we're asked about a lot these days is our cost-saving measures. Companies are shoring up cash, and they're wondering how they can save more to apply towards salary or redirect spend that they otherwise were putting into the 401k plan into other benefits, maybe an employee relief fund, disaster relief fund, or just in the form of bonuses or retention bonuses or salary to keep morale high. And so we've been working with a lot of companies about suspending their contributions to the 401k plan. And so really there's two buckets here, right? There's the non-safe harbor contributions, which are relatively easy to change. And then you've got the safe harbor matching and non-elective contributions. So for non-safe harbor, right, either your plan says that you'll have a discretionary match or a discretionary non-elective contribution, right? And so in that case, it's easy. The committee determines that they're not going to make a contribution to the 401k plan for that year. If it's baked into the plan document where it actually says the company will make a 3% non-elective contribution, then you would generally need to change your plan terms, and that would require a plan amendment eventually to change anything that's written in the plan document. It gets a lot more complicated when we start talking about safe harbor contributions. Typically, it's hard to get rid of a safe harbor contribution. There's two ways that most companies will do it. Either there's a special notice that you can provide within your annual safe harbor notice. So a safe harbor plan has to provide an annual notice to its participants that this is what we're going to do for the year. Here's our safe harbor contribution. And if the plan doesn't do that, then technically it's not a safe harbor plan, right? So you tell participants what it is, and you say you can rely on this through the year. There's a special provision you can put in that notice that says, unless we change our mind, effectively. This is going to be our safe harbor contribution unless we say otherwise. And if you do that, you could get rid of your safe harbor contribution mid-year if you give sufficient notice. The other way to do it is if you're operating on an economic loss for the plan year and you give sufficient notice, you can get rid of a safe harbor contribution. A lot of companies don't like to go through those steps, to determine whether they're operating on an economic loss, since the guidance is not crystal clear about what an economic loss means. And some companies don't like to put that reservation language in the annual safe harbor notice. So guidance that came out over the summer relaxes these requirements. You had to have taken advantage of it by August 31st. But for companies that did reduce their safe harbor matching or non-elective contributions by August 31st, and they made the amendment by that time, then they would not otherwise have had to comply with the other reservation language or economic loss standards. So it makes it easier if you did get rid of your safe harbor contribution. You potentially could rely on this new advice to not have to justify an economic loss if the IRS were to ever look at it. One of the really interesting things that came out of that guidance is that the IRS confirmed what we've long suspected, and it's that you can always remove a safe harbor contribution for highly compensated employees. We had a company come to us and say, hey, our match our safe harbor match is sacrosanct. We don't want to get rid of our safe harbor match. But one thing that we might put on the table, just if we have to, if it comes to it, is to get rid of the match for highly compensated employees. And generally, the rule is you do not have to provide a safe harbor notice to highly compensated employees. And because of that, you could technically get rid of a safe harbor match for highly compensated employees mid-year. And so the IRS, that's kind of been a suspicion, but never really confirmed by direct guidance. And the guidance that came out over the summer said, this is our position. We think that you can get rid of a safe harbor contribution for a highly compensated employees mid-year without having to jump through the normal hoops, which is good. So if you ever are in that situation, even past this year, it's good guidance for sponsors to have. Another thing we're getting a lot of questions about is utilizing remote witnessing. So the IRS regulations do allow for electronic notarizations, but those regulations still require that the signature be witnessed in the physical presence of a notary. Right. So temporary relief that applies just for this year will allow for certain electronic notarization. Right. So to qualify for the relief, individual signee must present a valid photo ID during the audiovisual conference, not as a follow-up afterward. It's got to be during the conference. The conference must be a live interaction, allows for interaction between the individual and the plan representative, so a pre-recorded call would not work. An illegible copy of the signed document must be faxed or scanned or emailed to the plan representative on the same day that it's signed. And if you do that, then you can do remote witnessing, which is helpful for a lot of clients that have big work from home populations, and those populations don't want to go out and actually have things notarized. To mention with that, we got electronic disclosure rules finalized earlier this year. And it's a good time too, because with everybody working from home, we can now rely on electronic disclosures for a lot of the retirement plan document disclosures that typically would be mailed out or hand delivered if the company cannot otherwise provide for electronic disclosures. So it's a new safe harbor. It's voluntary. It's not required to be sent out electronically. So if you're happy with the way you've been distributing plan documents, you could continue to do so. This only applies to retirement plans for now. So that's the big bummer about these rules, right? Because a lot of the paper that sponsors have to deal with, a lot of times deals with the health and welfare plans and mailing those SPDs or those booklets to participants that can't receive electronic disclosure. So brief recap of the rules, right? If you use a computer as an integrated part of your role at your company, you can generally get your electronic disclosures electronically. Otherwise, you have to provide an email address and affirmatively consent to electronic disclosures. The new rules, those rules had not been updated since 2002. And a lot's changed since 2002. So quick summary. So retirement plan disclosures can be provided to participants and beneficiaries by posting them to a website or mobile app if the participants provide their employer with an email address or smartphone number or an electronic address or one that's provided to them by their employer. To do this, you must provide participants, even those who are currently receiving electronic disclosures under the 2002 affirmative consent, with an initial paper notice. So we have to go back to paper. Paper notice explaining that electronic disclosures will be implemented and they have a right to opt out. The disclosure posted to the website must be in a format that's widely accessible, suitable for reading online or in print, and is electronically searchable. And each time that a disclosure is posted online, a notice of internet availability must be provided to the electronic email address that the participant has set forth for the disclosures. And then, of course, paper copies must still be made available if someone requests them. This is particularly useful for retirees. So people who, may not be active employees, who you're still providing plan documents to, you can utilize these electronic disclosures, for your retiree population. Okay, do we forget something? So during this time, we're drinking from the fire hose and chasing down pressing company issues about employee terminations and furloughs, and it's really easy to forget about your fiduciary best practices, right? Never forget about your fiduciary best practices, and during this time in particular, it's really important to have good oversight over plan activities, both in the health and welfare side and the retirement plan side. We're going to focus on the retirement plan side for now because that's where most of the litigation is around and most of the potential liability. But please think about your fiduciary obligations on both sides of the spectrum. During this time, right, you still need to review and monitor investment options. You still should have your committee meetings. Zoom makes it really easy to have teleconference and video conference meetings, as necessary to continue the schedule of having your normal meetings and cadence. And now, above all times, is a great time to review kind of your best practices, right? Your committee charter. Do you have your documents in order? Your IPS, when was the last time that was reviewed? Does it adequately reflect what you're doing? And to conduct training, right? So, we do a lot of fiduciary training. It usually it's best in person, but through this new work from home lifestyle, it's actually really easy to conduct fiduciary training now, right? Because you can just set up a Zoom and have your advisors come in and do fiduciary training for the committee, whereas that might have been a bigger deal to have them come into town if they're out of town. Now you can easily do fiduciary training. So now's a great time to take advantage of it and do fiduciary training, and don't be like the gift there. All right, so why do we care about fiduciary training? There's really two reasons, right? There's two ways that fiduciary issues can arise, either through the DOL, right, or through participant complaint, which leads to litigation. The DOL was exceptionally active last year. I understand that things have slowed down a little bit this year with the pandemic, but that things are getting ramped back up and underway now. And so things are kind of back to normal, business as usual in terms of audits and investigations. So this slide should scare you a bit. The DOL actively enforces fiduciary issues and seeks recovery actions both in litigation and through settlement. A lot of the information comes through informal complaints, right? So if you get that first phone call from the Department of Labor that says, hey, a participant called us and they have a couple questions, don't ignore that call, because oftentimes if you're proactive and the DOL gets the sense that you are practicing fiduciary best practices with respect to your plans, it can easily be resolved, right? But if it turns out that they feel that there potentially could be mismanagement, it could lead to an investigation or an audit. The other side, as I mentioned, is through litigation, right? And these settlements should scare you. These are large settlements over the past few years that are around everything from fiduciary processes, selecting your investment options, relying on your advisors, to fees, right? How much are you paying your advisors, and how much are plan participants having to pay for fees? A lot of these, are massive. The nationwide settlement was 140 million. And one of the things that I'll mention here too, as we'll go through, you'll see, is kind of the trend of non-monetary versions of settlement. So in addition to actual numbers and actual, settlement to plan participants and their attorneys, your courts are approving non-monetary aspects of settlement agreements. And that's actually a great thing for us to look at and study and say, okay, in addition to paying the money, what does the court think the committee should have done or needs to do now to move forward? Because it's a great roadmap for us to look at to decide what the committee should be doing, on a day-to-day basis. So most of the litigation that we see is fee litigation, both from the 401k side and the 403b side. And it all kind of boils down to either excessive record-keeping fees, like including revenue sharing or broker advisory fees, either as a percentage of assets versus a fixed fee, failure to capture excess revenue sharing, or there's a cheaper investment fund available but that wasn't used, like a retail versus an institutional class. Stable value funds should have been used instead of a money market fund, or underperforming funds should not have been selected, right? Like a hindsight is 2020 type of argument. And then, they all attack the process, right? So if you have a committee that has a good process and a prudent decision-making process, even if you pick the wrong funds, right, because they didn't perform as well as funds you could have picked, if you have a prudent process for picking those funds and you're, relying on your advisors and you're considering and weighing options as a committee, as you'll see, a lot of times courts will say, too bad, right? If you have a prudent process, just because you didn't pick the right one, the right fund, that doesn't mean that you should be liable for that, right? It's all about having a prudent process. So I want to talk about 3 cases today, and I will only bore you with 3 cases, and I'll try to make them as exciting as possible. And I won't bore you with the details of how we got there, but the Anthem case to start with. So ATH Holding Company is a subsidiary of Anthem. There was a monetary settlement of almost $24 million. There were non-monetary settlement terms, which I want to go through and show you what the court and plaintiff's attorneys thought that committees should be doing to better, have better fiduciary practices. So plaintiffs claim that plans fiduciaries breached their duties by using a more expensive share class of investments. For example, the plan offered Vanguard Institutional Index Fund with an expense ratio of 0.04%, but a lower share class is available at 0.02%. Less expensive vehicles should have been explored for the same investment strategies, including potentially collective investment trusts, which have become more popular, or separate accounts. And the plan should have offered a stable value investment instead of a low yielding money market fund. So the court said that they did not engage in a prudent process, right? And the committee was at fault. They did breach their fiduciary duties for not considering those lower class options, lower cost options. And I think the main takeaway here is these non-monetary term settlements. So let's go through them. So in addition to paying $24 million, the plans committee will provide a targeted communication to participants invested in the money market that includes a fund fact sheet, the historical returns in the money market, and the benefits of diversification. So they, reading between the lines here, the court thought that, and plaintiff's attorneys thought that the committee was not doing enough to explain this money market fund has a very low rate of return, and you might be better off having a diversified portfolio, and providing that kind of type of coaching and education to participants. Also, plan fiduciaries must conduct an RFP for record-keeping services. So one of the allegations, they're paying too much for record-keeping fees. And so as part of the settlement, they have to conduct an RFP for record-keeping fees. And they must explicitly request a fee proposal based on the total fixed fee and on a per participant basis. So really drilling down on the type of fees that are available, and so that they would weigh, what's best for the plan, right? The theme with all this, and I'll circle back to a few times, is you don't always have to go the cheapest, but you got to go with what's best for the plan. And then the fiduciaries must engage in an independent investment consultant to review the consultant's recommendations and make decisions based on those recommendations, taking into account the lowest class share class available, whether or not revenue sharing rebates are available, and alternative investment vehicles. So this is saying the committee did not do enough to throw a wide enough net to look at what type of other share classes are available to invest in. And so as part of the settlement, they have to go out and hire an independent investment consultant to provide that information to them to review and consider. And this is a good roadmap of things that committees should be thinking about now. When was the last time you did an RFP for fees? Are you paying the most reasonable fees for the plan? Are you considering different types of fee arrangements, whether it be a total fixed fee or on a per participant basis? Are you communicating to participants adequately about the risks of leaving money in a money market? Or are you engaging in independent fiduciary? And if you're not engaging in independent fiduciary, have you delegated those duties to someone else? And if not, are you really looking at the universe of possible options for your funds? The next case I want to talk about is American Century. So American Century was sued for using exclusively American Century investments in its 401k plan and not including any type of index investments, leaving underperforming funds on the watch list for too long and overpaying for investments, among other claims. It was an 11-day bench trial, and most of the committee members had to testify in court under oath. And the plan offered American Century funds, but contained a diverse array of asset classes and investment styles along with risk-reward spectrum. This is a great example of a committee who did their job effectively. They had a prudent process in place, and even though they didn't include index investments, or even though they left underperforming funds on the watch list, and even though they may have overpaid for investments, they had a prudent process in place. And as you'll see, it's a good one to think about in terms of what your committee is doing. So the fiduciaries were all cleared of wrongdoing based on their practices. Committee members had received fiduciary training, and they received information about their fiduciary duties. They were aware they were fiduciaries. They had access to plan documents. They had received their fiduciary training. They were aware of the responsibilities that come with serving on a committee. Before the meetings, the committee received the materials, including comparisons of fund performance and a watch list of underperforming funds. So even though they had funds that were on the watch list for a long time, they were carefully and consistently reviewing what was on the watch list or funds that were underperforming to put them on a watch list. The committee met regularly 3 times a year and had special meetings as needed. Whether your committee needs to meet 2, 3, 4 times a year depends a little bit on your company, but I think 3 is a pretty good minimum there. And to have special meetings as needed. And the committee members testified that those meetings were productive, lasted as long as it was needed to fully address each item on the agenda, right? They didn't have a hard stop where you'd say, okay, we're only going to allot 45 minutes to this meeting. And on average, the meetings lasted an hour to an hour and a half. So they had full time to review and consider the materials. It's really a lesson in having effective committee meetings. Committee meetings were well documented through meeting minutes, right? So they had someone take notes. Those notes were finalized, approved, and formalized through the committee process. And they relied on and considered advice from their investment advisor. So they received reports from an investment advisor. They carefully debated it and considered the recommendations in there. They didn't just rubber stamp what was coming from the investment advisor. They carefully considered different options. And those are the types of prudent practices that we'd expect for committees to be able to get out of a potential breach of fiduciary duty claim. Diving in a little bit here more, just to point out a few interesting points. So the plaintiffs alleged that at least one fund that was underperforming remained on a watch list for several quarters, but was never removed from the plan's fund lineup. Committee minutes, however, showed that the members had considered positive and negatives of removing the fund at each meeting, but had decided ultimately not to make any changes. And that's the type of prudent process that a court would look to determine whether you've got sufficient processes in place that you're carefully considering and weighing your fiduciary obligations. Plaintiffs also alleged that the committee was imprudent in waiting a year after the plan became eligible for a better share class before making any changes. So the plan was a little bit slow to adopt a better, cheaper share class. But the committee minutes and testimony from committee members demonstrated the committee considered this, making the change earlier, but decided to wait and coordinate the change in funds with a number of other service provider changes already being considered in order to minimize the disruption to participants. And that the court thought was a legitimate reason not to immediately move to a lower class, right? So you don't have to always go cheapest right off the bat, right? But you do have to consider cheaper options if they're available and determine what's best for the plan, right? And here the committee made a decision, carefully considered that it was best to wait, and the court generally respected that. Now, if the committee didn't have those minutes to be able to show that they carefully considered, these different options, or if they just didn't discuss it at those meetings, then this outcome might have been different. I also want to talk about the NYU case. This is another example of a committee win, right? So we can take from this a couple of takeaways for our committees. So the court heard testimony from committee members. Again, the committee members had to go and testify in court, and expert witnesses on the issue of procedural imprudence. So even though the court found troubling the level of involvement and seriousness with which several committee members treated their fiduciary duties, it concluded the committee as a whole did not act imprudently, right? So we had a couple of committee members who didn't take their jobs as seriously, but the committee as a whole was generally a well-functioning committee. The committee received good advice from its investment advisor, and the more well-equipped committee members as it performed its role adequately. I think this is a great example of why you need to have committee members who understand the importance of their role in the committee, and also understand that this is a serious obligation that they should carefully and deliberately consider as they're making decisions. It's also important why you need people on the committee who are well equipped to handle investment type decisions on a committee, right? You would want to find people who have the necessary background and education to be able to make these types of decisions and review financial reports and ask important questions. A lot of times with determining a prudent process, it's about asking questions, not just hiding your head in the sand. So the court concluded that the committee in the NYU case prudently monitored fund performance by receiving and reviewing detailed reports from its investment advisor ahead of meetings. They discussed performance at the quarterly meetings. Some of their members were active at meetings and asked questions in the investment advisor. And they used its investment policy statement for guidance on a quarterly basis. So not only were they updating their IPS to make sure it adequately reflected what they did, but they were relying on it and reviewing it and making investment decisions. And they also had a watch list to review struggling funds. So a couple lessons learned. So fiduciaries have an ongoing duty to monitor, right? So just because you put an investment in the lineup doesn't mean that it goes away, right? We have to actively monitor fund performance. We have to think about whether we should put those on watch lists. And once they're on watch lists, How long should they stay on a watch list? What's best for the plan? Is it best to make a quick course correction, or is this something that needs to be considered over a longer period of time? And a lot of times you'll rely on your investment advisors to help you monitor funds on watch lists. You must monitor fund fees, right, or plan fees, including revenue sharing paid by the plan for investments, record keeping, or broker and investment security advisory services. So everything that the plan pays for. How long has it been since you've done an RFP? And if it's been more than 3 or 4 years, when was the last? Is it time to do a benchmark, right? So you don't always have to do an RFP to determine whether you're paying reasonable fees, although it's a great way to determine whether you're paying reasonable fees. You can also get benchmark fees to determine whether what you're paying is market or not. And if it's not, and you're outside of market, is it time to request a different fee structure from your service providers, or is it time to go to RFP? If you haven't done that in the past few years, it would be a good time to kind of think about whether you're right to do an RFP. Establish and follow a prudent process for selecting and monitoring plan service providers, plan investment options, and related fees, right? So having a good committee process and actually implementing that process on a meeting by meeting basis of, here's how we're going to review fees, and here's how we're going to review investment options, and what are we going to do if it's not in line with market. Ensuring that the plan is operating in accordance with plan documents, right? So committee members should have access to plan documents. It seems obvious, but that's the first question that the Department of Labor asks when they go and interview committee members during an investigation or audit. Do you have access to the plan documents? And it's really easy for companies to set up just a shared drive and put all the plan documents, summary plan descriptions, IPS, committee charter, all in that shared file, and give access to the board member or to the committee members so that they can have access to the plan documents they need to fill their roles. Particularly, are you making decisions based on the IPS, and do your committee members have copies of the IPS, and when was the last time they reviewed it, right? So, asking committee members, before you come to this committee meeting, be sure to review the IPS. Periodically reviewing investment processes against the investment policy statements to ensure consistency, right? So I mentioned this earlier. Does your IPS adequately reflect what you're doing? And if it doesn't, is it time to make updates? The IPS doesn't need to be so narrowly tailored that you can't make changes outside of your current lineup, right? You want to have it broad enough that you can make investment changes, but it'll set forth your investment philosophy. And you generally would need to be operating your fund lineup in accordance with the IPS. And so if it's not consistent, should you make a change? Also, thoroughly documenting the basis for fiduciary decisions, right? So taking meeting minutes. It doesn't have to be word for word meeting minutes, and generally most advisors would caution against that, right? You want to have just a detailed summary of the issues the committee considered, and whether there was discussion and what the discussion was, so that if you are challenged on a fiduciary decision, you could say, no, look, the committee met, we had a thorough conversation about this. We considered all these options you're raising, plaintiffs, but at the end of the day, we decided this is best for the plan for these reasons. And having a document that you can easily show or produce is exceptionally important. And then last, conducting regular fiduciary training. So, setting aside some time before a committee meeting once a year or so to do a fiduciary update, to kind of go through some of the cases that we talked about today, so that the committee can have a better understanding of its role and duties as it moves forward. So with that, I'm done with the substantive part of the presentation. If there are any questions, I'm happy to stick around and have a conversation or answer any questions that you guys might have, either stuff that you're seeing with your company or anything that we covered in the presentation. Michelle, are there any questions at this time?
So I would like to encourage everybody, please use the Q&A or the chat if you would like to raise your hand for any questions. We do have a few. One of them is, how do you know what a good record-keeping service fee might be? Are there any specific red flags to look for?
No specific red flags. It's going to be relative to, your plan size, your assets, your participants, your company. I think the best way to get a feel whether you're paying this market is either in an RFP, like you would know whether the fees are market because you're reviewing other service providers, or to do benchmarking. And your current record keeper might be able to provide benchmarking information.
Okay.
Or if not, then your advisor should be able to provide benchmarking information.
Okay. And I do have one more. Should IPSs be reviewed in light of COVID-19 elements, or is it best not to, because COVID-19 is more of a relatively short impact?
Yeah, I worry a little bit about snap decisions related to COVID-19, right? Because, it might just be a temporary, affliction on the company, or on its philosophy with regard to investments. I mean, certainly, I was more worried if committees were making snap decisions, in April, May, and June, than I am now, right? Because the market is largely recovered. I think that an IPS could be reviewed in light of COVID, in the light of changes at the company. I think that it's a right time to review what you're doing versus what your investments say, to make sure that they're consistent and make sure that the IPS still reflects your philosophy. But generally, I don't think many committees are making snap decisions to change their investment lineup just purely as a result of COVID.
Okay. Well, I would like to open it up for any additional questions. And in the meantime, I would like to encourage everybody to please join us tomorrow morning. Once again, we kick it off at 10 a.m. Eastern time. And so it's a great way to get a educational start on your Friday. And then also, please visit SBEN, www.sben.org, to see other upcoming events that we have that might be beneficial to you. With that, I do not see any additional questions. And Scott, if you are okay with it, I think we give everybody about 5 minutes back in their day.
I think that's a great idea. And if you guys have any other questions you think of afterward, feel free to call me or email me anytime. We're always happy to help.
All right. Thank you, everybody. Have a wonderful day. See you tomorrow morning.